All right, great. Hello, everybody. We're going to start in a couple of minutes, but I just want to welcome all of you to today's webinar, the Juror Project that's being hosted by the Metropolitan Black Bar Association. So I'm just going to give it 1 or 2 more minutes for a couple of other folks to join in, and then we'll officially start the webinar. Okay, this is probably a good time to get started as any. So welcome to the folks who are in attendance right now. My name is Jason Clark. I'm the president of the Metropolitan Black Bar Association, and I'm here with our guest for today, Will Snowden, the founder of the Juror Project, to talk about the importance of jury service and diversity on juries. I want to let folks know that if they have questions, they should include it in the write it in the tab since everybody's on mute. If you look at your dashboard, there should be a tab that says questions, so you can put it in there, and I'll see it, and then I will address that question to the group. But again, the name of today's event is exploring the importance of jury service and diversity on juries. So just as a little bit of a background before I hand it off to Will, Will is the director of the Vera Institute of Justices, the Vera Institute of Justice in the New Orleans office. In this role, he continues and strengthens Vera's existing partnerships with criminal justice actors and community leaders while identifying new collaborative relationships with government entities and community organizations. The collaboration will focus today on improving criminal justice systems in the South. Prior to joining Vera, Will was a public defender for 5 years, representing New Orleanians in various stages of a case from arraignment to trial. Will also developed a focus and specialization in advocacy around reforming the procedures, systems, and policies around jury duty in an effort to promote diversity and representativeness in the jury box. Will also launched the initiative that we'll be talking a little bit more about today, the Juror Project, which is a initiative aimed at increasing diversity of jury panels while changing and challenging people's perspective on jury duty. As a felony trial attorney, William witnessed the discriminatory practices of removing jurors from jury panels, and it's in response to these practices that Will was prompted to create the Juror Project. So Will is from Milwaukee, Wisconsin, a graduate of the University of Minnesota, go Big Ten, and Seton Hall Law School. where he served as president of the Black Law Student Association. And yeah, this is probably a good time as ever. I'll pass it on to Will. Thanks for joining us.
Thanks for having me. I really appreciate it. Really excited to be speaking with all of you about what I've taken up kind of as a personal mission of mine to really increase the diversity of our jury panels, as well as improve people's perspective of the jury duty with an understanding that a tremendous amount of power has been given to the community that's in that jury box. And for a variety of reasons, we aren't necessarily tapping into that power. And this presentation is kind of an example of how we try to get the community informed about what is going wrong with the criminal justice system, but also give them a solution, imposing the opportunity to be on a jury as a solution to increase the fairness of our juries and the criminal trials that we have going around across the country. Next.
Let's see. There we go.
So I want all of you to take a look at this image, and I want you to think about how many triangles do you see. And I know that
So I guess the folks
are
want
muted,
to,
but just kind of just think about, you don't have to like type it in or anything, but just think about how many triangles you see. Just take a quick 5-10 seconds to count.
Yeah, and I guess if folks want to or they feel inclined to, they could try to put it in the questions tab, and I'll try to look them up.
In thinking about how many triangles we see, typically when I ask people this question, people offer 6, 9, 11, 12, and occasionally somebody will say 0. And that is actually the correct answer. There actually aren't any triangles in this image. And so hopefully some of y'all are thinking to yourself, well, actually, I thought there were 3 or 5 or whatever it might have been. And realizing that our brains can be primed in a particular way to activate schemas to see things that aren't really there. I like starting with this little exercise because we'll be able to come back to it when we have conversations around implicit bias in the jury box. Next. I want you to take a look at this image. I want you to think about what's going on, what you notice, and what you think is happening. And as you're viewing this image, one of the things that you might notice are the different colorations of black figures and white figures. And another thing that you might notice is that there's a jury in the top right corner with 12 people, and it looks to be all white. And the person who drew this image is an individual by the name of Earl McGahey. And in 1986, Earl McGahey went to trial for a capital offense, and he was found guilty of that capital offense. And what he noticed was the demographics of the jury didn't necessarily reflect the demographics of Selma at the time. And in fact, there were 55% African-American population of Selma County, but as you can see in this image, there was not 55% representation in the jury box. Mr. McGahey was later exonerated for that capital offense. And I think it's very interesting that he drew this image beginning to touch on the issues of race that we see in the courtroom and how the diversity or lack of diversity can impact the outcomes of cases. Next. I looked around the courtroom. The judge was white, the prosecutor was white, my lawyer was white, the jury was white. Even though I was innocent, I knew I had no chance. These are the words of an exonerated death row prisoner, and when we think about this quote and the image of Earl McGahey, I think both of these individuals are really putting their fingers on an issue that we have throughout our country, and it's the fact that our juries lack diversity, our criminal justice systems lack diversity, and a product of this lack of diversity is in fact a lack of fairness. Next slide. So we're talking about jury duty, and oftentimes you might see yourselves in situations talking about jury duty, and I think we all know that there are people in our communities that think jury duty is actually something that is a duty that we should be trying to get out of. With the Juror Project, what we're trying to do is really change people's mindset around this civic duty, to see it as an opportunity to create a great, or to offer and have a great impact on the criminal justice system, as well being involved to make sure people are getting fair trials. And so some of the terminology that we constantly review with members of the community is voir dire. And we all know that voir dire is a conversation between the attorneys trying to figure out who would be a good fit for the case. You can hit the next. And the next one. We also educate individuals about the different types of tools that are available to the lawyers to remove people from the jury. So one, as we most all know, is a cause strike. There are unlimited amounts of cause strikes. There are peremptory strikes as well, and there are a limited amount of peremptory strikes. When we're meeting with folks in the community, I think it's very important to make sure they are aware of how there are tools that can be used to remove them from that jury box. Next. Batson versus Kentucky is a case that we probably all know. It's a case from 1986. We are familiar with the fact that Mr. Batson was charged with theft-related crimes, and then when he goes to trial, the prosecutor ended up utilizing all of their strikes to remove the black folks from the jury. And when this case goes up to the Supreme Court in 1986, they develop what we are familiar with as a Batson challenge, or this Batson test, really to be utilized as a tool to basically weigh whether or not a particular attorney is participating in juror discrimination. And the Batson test, it's a three-part test. The first part is the attorney needs to raise an objection to the striking of particular jurors. The second is for the opposing counsel to provide their explanation. And the third is for the judge to determine whether or not that explanation was in fact race neutral. Next. On the Supreme Court at the time was Justice Thurgood Marshall, and in reviewing this decision, he says, the decision today will not end the racial discrimination that peremptories inject into the jury selection process. That goal can only be achieved and accomplished by eliminating peremptory challenges entirely. And when we think about, what criticisms we've heard of this Batson case, it's that if we have created this three-step process for attorneys to really try to challenge other attorneys in ways that they have been using their strikes, the attorney can really just give whatever answer that they want, and that can really mask and disguise the discriminatory intent. And that's part of what Justice Thurgood Marshall is getting at here. You can do next. So what are some cases? Obviously, 1986 was a while ago in Batson versus Kentucky, but we're still seeing, discriminatory behavior, not necessarily by the attorneys, although there's some of that as well, but of the jurors that are saying things that are really concerning. And I wanted to highlight this case, which is a case from 2016. Miguel Angel Peña Rodriguez is charged with, I'm sorry, this case it's from 2010, but the Supreme Court decided it in 2016. Mr. Rodriguez is charged with sex-related crimes. He's found not guilty of 2 of those crimes and is found guilty of 1. And when there was some post-conviction investigation, speaking with the jurors in that case, one juror had this to say about Mr. Rodriguez and the reasons why he voted guilty. This juror says, "I think he did it because he's Mexican, and Mexican men take whatever they want." And so when we look at this quote, we search for any type of reference to evidence that came out during the case, any type of reference to testimony, anything that was really relevant, in particular, material facts that were presented over the course of the trial. And what we see is this juror is really only voting on their prejudices towards Mexican American men. And when this case goes up to the Supreme Court, the issue that was presented was whether or not this type of discriminatory prejudicial mindset could be cause for a new trial. And there was something called the no impeachment rule. And what that basically means is that jury box during the deliberation period is supposed to be like Vegas. What happens there is supposed to stay there. And when this case goes up to the Supreme Court, they ended up overturning the conviction on that one count based on the fact that the government should not be able to sustain a convention that was based on this type of prejudicial mindset. And so Mr. Rodriguez did get, in fact, a new trial. I bring that example up because as attorneys, when we think about voir dire, we think about how do we ask questions that could potentially reveal these types of biases. And as a public defender for 5 years, I struggled with trying to get the truth out of individuals on how they might have opinions about the individual that I was representing. And I think this is a good example about when we're unable to reveal some of those biases, that they really do have an impact on the outcomes of the case. For those folks that are interested in good recommendations about voir diring on race, I do recommend looking well, it's part of the National Association of Public Defenders website, but they have webinars that's led by Mary Moriarty, who is the chief defender in Hennepin County, which is Minneapolis, Minnesota. She has a really good webinar that it's publicly available to all of you that are listening today to get some tips on what are some successful questions you can be asking about race, how to voir dire about race, and how to potentially reveal some of these biases. Next. So we're talking about the need for diversity on our jury panels. And so we can talk about the need, but we should talk about some of the harms that are resulting from the lack of diversity and harms that are resulting from racial discrimination during jury selection. And so one of the very first places we can start is that it violates the right to a jury by your peers. And I think that's something that we as attorneys obviously are familiar with. But hopefully part of this webinar, you can think about how you can have conversations with members of your family, with members of your community, with members of your church, just members that you're able to have, people that you're able to have contact with to really get them to understand the importance of jury duty and the fact that if you were not, in certain states of the country, if you were not a property owning white male, you did not have the right to be on a jury. And the individual that was going to trial has a right to a jury of their peers. And so really thinking about what does a jury of your peers look like, we would argue that there should be representative diversity on the jury that mimics the demographics and ideologies of your community, of the county, of the parish, wherever you might be, on the actual jury box. Next. And one more. Additionally, harms resulting from racial discrimination during jury selection, it really undermines the notions that the criminal justice system operates in a fair and race-neutral manner. I want y'all to think back in your mind about that image that Earl McGahey drew. Right, and there's an image of the courtroom in Selma, 1986, and we see the all-white jury, and we see presumably the black defendant. And for most of us, race crosses our minds, as it should. And I think that type of reaction is elicited by the imagery there. But also a context of that imagery is this person going to have a fair chance? And for most of us, when we see that image, we are concerned about the outcome of that case due to the lack of diversity on that jury. Next. So what are some reasons for diversity on a jury? So we all know that two minds are greater than one. And I think that's kind of a very basic principle that we have learned as kids in our childhood and even in our adulthood, the benefits of collaboration with somebody that might think a little differently than you. Next. When we think about a diverse jury, the research demonstrates that we actually have longer deliberations. Next. And one more. The research also demonstrates that more questions are being addressed in the deliberation room and a more objective decision is going to be made. Additionally, with diversity, implicit biases can be countered. And for most of you that are listening in, you might be very familiar with implicit bias, which is great. And implicit bias, for some of us, we're not familiar with. And so we're going to go into a little bit about what implicit bias is on a very basic level in this next slide. You can hit next. One more. So the kind of scientific definition of implicit bias, it's the bias in judgment and or behavior that results from subtle cognitive processes that often operate at a level below conscious awareness and without intentional control. So when I read that, what it means to me is like I'm doing things not really knowing why I'm doing them. And we all have implicit biases, and for those of us on the webinar who consider ourselves to be fair, pragmatic, social justice oriented, and have this egalitarian mindset that we have dedicated our lives to be fair and impartial and really give everybody a fair shake, we have implicit biases. And it's not anything that's related to our good intentions, right? Good intentions do not reduce the amount of implicit biases that you have, because remember, implicit biases are operating on a subconscious level, something that we're not intentionally in control of, and something that might not be consciously aware of. Next. One little piece of homework that I would encourage all of you to do, if you haven't done it already, is take the implicit association test. The implicit association test is important for all of us to take, especially for us who are attorneys on this webinar, because implicit biases are impacting the decisions that we're making. And part of our profession is to not only make decisions, but to give people advice on how to make decisions, to counsel them in situations where they're making important decisions. And if we know that implicit biases are in fact impacting the decisions that we're making, we owe it to ourselves to know what our implicit biases are, but we also need to owe it to the individuals that we're interacting with, that we're providing counsel for, on how implicit biases can be impacting our judgment as well. So you go on to the implicit association test, and essentially what that's going to measure is your reaction time for between the correlation of certain images and certain words. And it measures your reaction time of making those correlations to demonstrate if you have an easier capability of associating negative words with particular images, or if you have an easier capability of associating positive words with certain images, and how that correlation time can really reveal a type of bias that you might have based on some automatic associations programmed into your mind. 2016 was a year that we had a lot of police officer shootings, and there was a lot of research around what we call shooter bias. And I just mentioned that here as part of the mind science research that is going on, just so that you know that shooter bias is the research around a law enforcement's officer's likelihood to mistake an object in an individual's hand for a weapon. So we think about cases in which somebody had a cell phone in their hand and it was mistaken to be a gun. Shooter bias is the research around how that can be misperceived as an actual deadly weapon. Next slide. So we started this conversation with this image of how many triangles do you see? And we think about how implicit biases are developed within us. And I can say triangle, and immediately a schema is going to be activated in your mind to fill in the lines of this triangle. And some of us might actually can remember doing that when I asked how many triangles are here, and in your mind you started to connect the lines to really have your brain put something that was there that really actually was absent from this image. Next slide. And one more time. And thinking about how are our brains filling in these lines of triangles, I want to talk about how implicit biases are developed in our minds. And the first thing I want to just mention from the very beginning is how cute this kid is, right? He's absolutely adorable. He's got this little kind of beauty mark underneath his eye, and just all around cute kid. The second thing I want to mention is this executive summary put forth by the Perception Institute, who does a lot of research in the area of mind sciences of implicit bias, racial anxiety, and stereotype threat. This executive summary dives into how biases are being developed within us as members of society. And it's largely, they take a very large look at how young Black men and boys are being represented in media. And what this report shows is that Black men and boys are represented in media primarily to be praised for their athleticism, to be praised for their entertainment, their musicianship, whatever it might be, and then to be demonized for their criminality. So it's important that we kind of unpack that a little bit about how in the media we are being fed these images that are developing schemas within our minds. And schemas just generally are understandings of the utility of a particular object, or understanding on what a particular object stands for. So a very basic example, there are some of you that are sitting on a chair When you walked into the room and you saw that chair, the schema was activated in your mind that a chair is something that you sit on. And so with this executive summary, these schemas are being developed in our mind, associating young black men and boys with athleticism, with entertainment, and with criminality. So I want to take a moment to think about if we are being exposed to this imagery, if we are being exposed to the development of these schemas, and then we sit on a jury, how does that harm the individual sitting at the defense table? If you are a juror who might not have regular interaction with people of color or people that are being more commonly being brought through the criminal justice system in your county, and you have these schemas that have been developed in your mind about people of color, about young black men and boys, you sit in that chair in that jury box, you look at that individual at the defense table, let's say it is a young black man, and in your mind, your brain is automatically going through schemas trying to figure out more information about this individual. And so your brain will go through the schema of, is this person an athlete? And we'll look for context clues and say, no, this person isn't an athlete because they're not wearing a jersey, they're not holding a ball. So then our brain might go to the next schema of, is this person an entertainer? And your brain's going to say, no, this person isn't an entertainer because they're not holding a microphone, they're not holding an instrument. And then your brain will then go to the schema of criminality. And before the prosecution or the defense attorney has begun their opening statements or the case has started, this individual already has some prejudgment going on against the defendant at that table. And so I bring that to the attention of the group to think about how can we promote more ethical jurors or more responsible jurors or more fair jurors. And I think it's being ambassadors around the research of implicit bias, being open and honest with the implicit biases that we have as individuals, and really be challenging the members of our court to allow us to discuss implicit bias during voir dire. Next slide. One more.
No one can hear? Can anyone hear this, or?
No, it's not coming through on my end.
Okay.
I want to just take a little moment of personal privilege to inform you all in New York something that's going on in New Orleans or in Louisiana as a state. We have something called non-unanimous juries. And what that means is if you go to trial and there are 12 people on your jury and 10 people vote guilty and 2 people vote not guilty, that person will still be convicted and go to prison. I think it's important for everybody to know what's going on here in Louisiana because we talk about Louisiana being the prison capital of the world. And we talk about how we have so many people that are behind bars. It puts forth this idea that we are a dangerous state, that we have high crime, and that our criminal justice system is doing a very good job at locking people up. When people mention that Louisiana is a prison capital of the world, in the same sentence, they need to say that Louisiana is the exoneration capital of the world. And what that means is that our juries are getting it wrong more than anywhere else, right? And what's unique about Louisiana, as well as Oregon, is that we have non-unanimous juries. When we look at the number of individuals that have been exonerated, 40% of them have been exonerated that were originally convicted via a non-unanimous verdict. Let me say that again. Of the individuals that have been exonerated in the state of Louisiana, 40% of them were originally convicted via a non-unanimous verdict. So what that means is at the time that individual went to trial, there was either one person or 2 people who voted not guilty, but they could not prevent an innocent person from going to prison. I'm very excited to be part of a group of amazing leaders here in Louisiana that are promoting the passage of a bill requiring unanimous juries. And the people in the state of Louisiana will have an opportunity to vote on November 6th to require unanimous juries. It's important to understand in context, there are 48 states that require unanimous juries. The federal government requires unanimous juries, and I'm very optimistic and hopeful that on November 6th, we are going to be able to pass this bill and require unanimous juries as well.
So Will,
Yep.
Just out of curiosity, so I know you had mentioned that it's not just Louisiana, but it's also Oregon who has non-unanimous juries. And I don't know, maybe some of the other folks are at least more well informed than I, but I certainly wasn't real. I was certainly wasn't aware at all that this is something that was done or even legal to do. But I guess on the state side, I guess people can do what they want to do. Uh,
Hmm.
the question I have is, have you, and I'm not sure if you'd had this information or at least a thought like at your fingertips, but you said that there's a 40% exoneration rate with folks with non-unanimous juries in Louisiana. Do you have any ideas like what those numbers are looking like in Oregon as well?
I don't have the information for Oregon, but that is a good question to look into. I would like to share a little history about non-unanimous juries. So in Louisiana, um, they really were a product of the Constitutional Convention from 1898. And it's important to consider what was so significant about 1898. At this time, there were 138 Confederate senators that were trying to figure out still what they were going to do with this relatively newly freed slave population. And they made this mechanism of non-unanimous juries for two reasons. One, to make it easier to convict black folks, because remember, Louisiana, there was a big, huge economy around slavery, lots of land, lots of slaves, lots of money. And when the 13th Amendment took away that work support, with the exception of criminal punishment, these individuals were still trying to figure out how they can support their economy with this labor. So they wanted to make it easier to convict black folks. And they also wanted to nullify the black vote if and when a black person got on the jury. In 1898, what we know, actually it was 1896, what we know is there were roughly 400,000 African American voters at the time. And in Louisiana, if you register to vote, you also get the right to be on a jury. So they were worried about those black folks getting on the jury and interrupting their sense of justice, in the sense that they aren't going to be able to convict people as easily as they used to. So the real intent behind non-unanimous juries is rooted in racism. We think about Oregon, and a lot of people are like, wait, Oregon doesn't, well, they're not known for having a lot of black folks.
Hmm.
So where does Oregon's non-unanimous jury scheme come from? Theirs is a result of anti-Semitism. There was a Jewish man who was charged with murdering a Protestant man, and there was one individual on the jury who did not think it was murder and voted for it to be manslaughter, and ended up convincing the other 11 jurors to vote manslaughter. And the white Anglo-Saxon community of Oregon was very upset that A, this Jewish man did not get the murder conviction, which would be a life sentence in Oregon, and B, that this Jewish immigrant that was on the jury was able to hold up, the conviction that the other 11 folks actually wanted. And there were a lot of criticisms over immigrants at the time. I think it was 1908. Um, immigrants. I mean, even now, I guess immigrants have. For some immigrants, there's a stigma assigned to them. But there was a lot of concern about the influence that these immigrants were able to have on the criminal justice system in Oregon, and so they created non-unanimous juries as well.
That's interesting.
Yeah.
Okay.
Next slide. So just some information when we're talking about diversity on juries and its benefit. We know in Louisiana, when they looked at 300 trials over a 10-year period, we were able to look at this data. And what it shows is that when 300 plus trials over a 10-year period, when there were not more than 2 black folks on the jury, there were 0 acquittals. But what happened when there were 3 or more black folks on the jury? Well, the acquittal rate increased to 12%. When there were 5 or more black folks on the jury, the acquittal rate increased to 19%. We like to look at this data as a direct representation of the impact that diversity can have on our juries. We know that with more diversity, there's actually more fairness. In this case, we see those 2 individuals, 2 black folks on the jury, 0 acquittals, largely because of non-unanimous juries in Louisiana. But really think about the impact that diversity can have in all of our cases, and how the outcomes can be so different when we have that diverse representation. Next slide. So one thing we like to ask members of the community, and I'm hoping, part of this presentation, what the attendees are able to take away with is an example of how we as a Juror Project have conversations with members of the community about jury diversity. When we talk about the lack of jury diversity, we have identified really 3 different categories that are contributing to the lack of diversity. The first category is the way that we are summoning jurors. In majority of jurisdictions, the jurors are being summoned by not by voter registration, as well as DMV records. So if you are registered to vote, you can get called for jury duty. If you are, have a car, you can get called for jury duty as well. The problem with that is not everybody's registered to vote, and not everybody owns a car. We should be thinking and questioning, why are we using those lists when we know that there are some inherent biases baked into it? New York uses a few lists, not just voter registration and DMV records. I think we looked at Kings County in Brooklyn and New York, and the lists that they use are registered voters, holders of driver's licenses, or state IDs, New York State income tax filers, recipients of unemployment insurance or family assistance, as well as volunteers. And so New York is, doing a little bit better in the sense that they're using a variety of lists, which can more encompass members of a particular county. And that's what we should be thinking about, is what are the best ways in which we can be summoning jurors. Massachusetts has really great practices in which they use something called an annual resident list. What this list does is it has all the names of the individuals living in that county for that year, and they just summon people from that list. And that list is used to supplement the voter registration and DMV records. And so it really allows a particular jurisdiction to summon jurors in a very representative way. So the first thing that we think about lack of diversity is the way that we're summoning jurors, the way that we're getting them to the courthouse to begin with. A second way that we think about the lack of diversity on our juries is the voir dire process, right? It's the questions that are being asked by some prosecutors that are specifically trying to remove certain individuals from the jury. So what I've seen when I was in New York, my experience in New York, I worked at the Manhattan District Attorney's Office as a paralegal. I worked at the Bronx Defenders as an investigator. So I was able to kind of see both sides and the way that either side would do their voir dire. And something that I saw amongst prosecutors, some prosecutors, and I'm not saying that all prosecutors subscribe to this, is that they will ask particular questions that they know will elicit affirmative answers from people of color. So for example, a common question that I would see is a prosecutor asking the members on the jury, how many of us have had bad experiences with the police department? And when we see that question asked in New Orleans, inevitably, majority of the black folks on the jury will raise their hand. They will discuss the bad experiences they've had with the police, and the prosecutor is able to use those reasons to remove those folks for legal cause. I have a problem with that, and I hope some of you on this webinar have a problem with that as well. If we think that there is not value in those experiences for a trial, we need to be having a longer conversation. What the Juror Project promotes is diversity in every sense of the word. We want people on the juries that have had amazing, trustworthy, positive experiences with police departments, just as much as we want individuals who might have had negative experiences with the police department. We want that for 2 reasons. A, that's going to be representative of the community in which this individual is going to trial. But B, it is also going to give us faith in the outcome of that verdict. Because if we have somebody on the jury who loves the police and somebody who hates the police, and those 2 individuals are able to come to the middle and agree on a verdict, we as a society can have much more faith in the outcomes of those cases.
Yeah.
So a second area is voir dire. Yeah, go ahead.
Yeah, no, and actually, and maybe what I'd add too is obviously there's been like a host of shootings of African American males, as in particular, by police officers, and a lot of times people just get more frustrated with the system when they get through, and either one, they can't get past a grand jury, but even when they do, in those few instances that they do, it seems like folks where, folks who, at least on the outside, seem like they had done something against the law, they just aren't being held accountable for it. And I would
Mm.
imagine that also helps to almost more of a feeding of this concept that the system isn't fair and it's rigged against you. And I think this goes back to some of the things you were talking before about trying to preserve the sanctity of the justice system. And the way you do that is making sure you have diverse jury pools. But
Absolutely.
and actually, there's one other thing before you were talking about what they were doing to try to increase jury members in New York, and at least one of the proud things I'd say is that there is a judge, a former Supreme Court justice here in New York County, Milton Tingling, who is also a very active member of the MBBA. And now he actually stepped down, and this hadn't really been done before, but he stepped down from being a judge so that he could be the first African American clerk for New York County. And as clerk, one of the things that he said that he was going to do was try to do a lot more to make sure that we diversify the jury pools. And I'm not sure if this is something later on that you were going to start to touch on, but he mentioned that a lot of the reasons why we have folks, why we don't have jury pools that are reflective of the general population there, is because those, for example, who, let's say they've been incarcerated at some point, they aren't voting, and so they aren't on the voting rolls, or they aren't, driving, or they aren't. I think there was another thing he had met, another way that they identify voters. But I was just kind of curious as to if there's a way we can actually try to reinstate folks, into some of those potential jury lists that have been in the system before, who are now eligible to vote and serve on juries.
Yeah, and I think that's definitely something we should be considering is how do we get these returning individuals that have been system involved, how do we get them back into society in more ways than one? I think we talk about housing, we talk about employment. We also need to be talking about civic participation.
Right.
And that's definitely something that we should be concerned about because they have valuable experiences and perspective as well.
Mm-hmm.
So we think about ways that we can increase diversity. We talk about the way that jurors are being summoned. We talk about voir dire practices. And one of the things that the Juror Project really focuses on is the individual in the room, is the members of the community that are getting called for jury duty. We don't want them to have this negative mindset. We want them to really see this as an opportunity to get on the jury and ensure somebody is actually going to get a fair trial. And the way that we do that is we have presentations like these. We have conversations about how they can be involved to just simply listen to a particular presentation by prosecution, listen to the defense, and be part of the conversation deciding who we think our system should be sending to prison, who we think our system should be branding a felon or somebody that is charged with a misdemeanor. Because at the end of the day, we are living in the society, so we should be part of the conversation on how we think the best way to keep it safe.
Okay. And just as a public service announcement, if folks have any questions, since we're already at 1:45, definitely make sure you put them in the questions tab, and I'll make sure that I bring them up to Will.
Yeah, and I'm wrapping up so we can excited to get to those questions. You can go to the next slide. And you can click about 3 times. There you go. One more. So when we think about when we think about civic duties, excuse me, we have conversations around military service. We have conversations around voting. But too often we aren't having conversations around jury duty. And we can, at sometimes as attorneys, get focused on how can we have a better voir dire to get more diversity on our juries. And it's not just diversity of race, it's also diversity of ideology, diversity of thought, diversity of experience, diversity of background, because we know, and the research demonstrates, with more diversity, there is more fairness. And that's what we all want with our criminal justice system. We should also be considering what other ways can we be having this conversation. And so the Juror Project has been able to create a jury duty unit plan for high school civic teachers to use to teach their students about jury duty. Because when I was coming through school, I didn't learn about jury duty. And it probably wasn't until college or law school that I learned about jury duty, but I had heard people talking negatively about it. One thing that worries me is, our young adults, as they're graduating high school and they come out into the real world and they get exposed to this negative mindset around jury duty, that negative stigma is just going to continue to cycle through these generations as they're coming out of school. So our unit plan is a tool for teachers to utilize to get their students excited about jury duty, to really kind of establish a new framework around how they should be seeing this opportunity, to really empower them to feel like they have a sense of involvement in the criminal justice system. Next slide. This isn't applicable to you because in New York, you guys aren't voting on November 6th, but in Louisiana, we are. And so it would be really great if I can send a message to Paula and to Jason to let y'all know about the victory that we were able to have down here in Louisiana, because it is such an important moment. I think it's a very unique opportunity to have a beacon of light in what for some of us think has been a blanket of darkness in our country right now. There's some awesome criminal justice reforms that are happening around the country. What we know is criminal justice reform is a collaborative process, and we're very excited here in Louisiana to hopefully pass this on November 6th so that we can have a more improved criminal justice system. And I know that this isn't something that's applicable in New York, but I think it's important for all of us to be aware of the different types of issues that are happening across our country. One, to be aware so that if it tries to happen in our home states, we can know how to resist it. And two, if we think of ways of supporting other folks in our networks that are in different states, we are at least informed about those issues. Next slide.
Okay.
It has been a true pleasure to have this conversation with you all. When I give these presentations, the most exciting part for me is actually the dialogue that I get to have with people. I know webinars kind of present a different dynamic, but it was still a real pleasure and a joy to go through some of this information with you all about jury diversity, about how we are taking certain approaches to increase the juries. Not just here in Louisiana, we've given presentations in 10 different states across the country and are continually expanding. If you are interested in just kind of keeping track of some of the work that we're doing, feel free to go to our website. If you are in front of your phone or your laptop, feel free to go on Instagram, Facebook, or Twitter and join us at Juror Project. Thank you.
Great. So actually a couple of things. So one question that I see we've gotten in the queue was just a little bit about, so obviously we've heard, what you're saying, we're on board, we want to make sure that we have diverse juror pools. What is something that we can do to try to ensure that, jury pools are more representative of or rather defendants are more, have a jury more representative of their, of their backgrounds moving forward? Like, what can we do as individuals? Or even as attorneys?
Yeah, as attorneys, so it's kind of twofold. One is you can be ambassadors about changing the mindset around jury duty. You might be in situations where people call you and they ask you how to get out of jury duty, and you should really be correcting and changing that mindset. As an attorney, one thing that I'll share with Jason and Paula to share with you all is to take a look at a rule that had just been passed by the Washington State Supreme Court that has really done a dynamic job of protecting diverse experiences, particularly as it relates to involvement with the police. And essentially what these rules do is it addresses implicit biases, but really when we have seen instances where people are being removed from the jury because of their experiences or involvement with police officers, this rule makes that experience presumptively invalid as a justification for removing that person from the jury. So when we think about in the criminal cases, when we see the question being asked, how many of you have had involvement with the police officers, that can no longer be used as a reason to remove somebody from the jury. So I'd be excited and more than willing to share that ruling with you all so that you can think about what are the conversations that you need to be having with different judges, with different officials in your counties, or maybe even at a state level, to get that type of reform established in your systems.
Right. Another question that I'm seeing, and it's related to jury, but a little bit I'm not sure if it's exactly in your wheelhouse, but one of the things that we seem to have seen sometimes is, let's say there is a officer uh, who's had charges brought against him for, a lethal encounter with an individual. Sometimes, what, at least especially in New York, what we'll see happen is, even though, let's say, the incident happened in the Bronx, the attorney will make a motion for a change of venue, citing that they won't be able to get a fair hearing or a fair verdict in that particular venue where the actual incident occurred. Do you have any thoughts? And obviously, I think the idea behind this is that if, for example, they had it changed to somewhere upstate where it's historically it's been a little bit easier to get an acquittal. I mean, do you have any thoughts on what people can do or different ways that we can maybe try to prevent things like this in the future?
So you said it's easier to get an acquittal in upstate?
Yeah, well, I mean, historically, right. Sometimes what we'll see is, let's say there's an officer who's engaged with a,
Oh, an
with the
acquittal of the
shooting.
police officer.
Right.
Sorry.
Yes. I'm
Yeah.
sorry. Right. As a police, and then they'll try to move upstate where there,
Hmm.
it seems to be a little bit more, sympathetic to officers, and just assuming that,
Right.
the idea of qualified immunity has a lot more resonance up there than maybe
Right.
down here.
So I don't have any particular recommendations, but that is something that is very frustrating. And when we think about what role can community play in holding folks accountable, it's so important for members of the community to be able to sit in that jury box and judge something that may or may not have happened in their neighborhood or in their backyards. I don't have any particular motions. I've never really contested a transfer of venue in this type of scenario. So I'm sorry I don't have more information on that.
Yeah. Sure. No problem. Let's see. So let's see if we have any other questions. Um, so one other thing that's also coming to mind is a lot of what we'll hear is that there will be folks who say, I'd love to be able to sit on a jury. I know that it's important, but you know, I have a couple of kids. I can't really, I have a job where I really can't miss work. And, I just have some of these other responsibilities, which is preventing me from, really putting in that time or really wanting to, do my civic duty to be on a trial. What is it that you'd say to them, or what would you suggest that folks of us who, agree with you would say to those type of individuals?
Yeah, so I definitely value um, that that reality, right? People need to be able to provide for their kids. People need to be able to take care of their families. So my mindset really goes to first, let's recognize how the system has designed jury duty to be more feasible for certain individuals and more burdensome for others. Second, I think about how we can be expanding a rule that is in place in some jurisdictions, not all, is really just an idea of a 1 day, one trial rule. So some jurisdictions require jurors to report, every day for a 2 week period. They sit in the juror lounge and they wait to see whether or not they're actually going to get called. Um, and that's just not an efficient use of people's time. And so some jurisdictions, what they do is you show up for 1 day. If you get called for a trial, you sit for the duration of the trial, and then you go home. That's one way to be a little bit more efficient with people's time. But to the particular question of like, what do I do? I have, kids I need to take care of. I respect that burden. I think about how we could be more supportive of those types of individuals. You know, realizing that childcare is something that is difficult for some to arrange. I don't know if jurisdictions could be providing childcare while people are sitting on a jury. That's probably unlikely, but it's something that we could at least discuss and brainstorm around. But I do remind individuals to think about whenever we have seen a verdict on the news that we disagree with, or let's say, there are some people in the country who are very upset that the officer was not held responsible for Orlando Castillo's killing in Minneapolis, or that there was a mistrial in, I think, South Carolina for the officer who shot and killed Walter Scott. When we as individuals have criticisms of these verdicts that are being delivering, and we try to get out of jury duty or we end up making excuses, we are actually part of the problem and not the solution. And so I try to remind people that their 1 week or 2 week sacrifice, A, literally could be saving someone decades in prison, or B, it literally could be the difference on somebody being held accountable for a crime they committed. And so really understanding the value and the role that we all play in our societies to be part of that judgment phase, to determine whether or not the case has been proven beyond a reasonable doubt, is very, very important and something that we should be considering as a tremendous, value and tremendous importance to contribute to the overall well-being of our society.
Mhm. Yeah, well said. Also, because I heard mention about some voting dates, and since they'll be coming up, because I always look at it, the responsibilities of a citizen. You have at least two. One is to serve in jury duty, the other is to vote.
Hmm.
So just for folks to keep in mind, the state primary election date is September 13th, and the general election date is November 6th in New York. So.
Great.
But with that said, I think this, I mean, unless I see anyone with some last second questions, give you another couple of seconds. But with that said, I just want to say thank you all for taking the time to speak with us. There are definitely a few things that I thought I knew, but then I learned a lot more while I was here. And I'm sure I could probably speak for the rest of the folks who are attending this program that it's probably, I would like to think it's probably the same for them. So thank you for your time. And this is another chapter in MBBA's webinar. And I don't know, Will, do you have any last words?
I don't. I really just want to say thank you for having me. It's been a joy to have this conversation with you all. Would love to eventually train some folks in the New York area to give these presentations to members of the community, because I really do think this is an agenda we should be tapping into to share as a resource with our communities to improve the criminal justice system.
Mhm. Sounds good. Yeah, great. And of course, you certainly feel free to reach out to us to see if there's any way we can assist with some of those things.
Thank you so
Uh,
much.
So with that said, thanks everybody for tuning in for the most recent edition of the MBBA's webinars, MBBA Learns. My name's Jason Clark. I'm the president of the Metropolitan Black Bar Association. We've had Will Snowden, who's talking from the Juror Project, and make sure you serve on your jurors. Thanks.
Thank you so much.